All right, all parties are present. I'm told the jury has reached a decision in this case. Before we bring in the jury, we tell those people in the audience here, regardless of what the jury's decision is, it's very important that people do not react emotionally to it. We have to remind ourselves of two things. So number one, the jurors are conscripted to be here. They're not here by choice. And two, is very much reflected in the proceedings in this case, where I've had to have 4 or 5 people arrested for not cooperating with the jury clerk's instructions to be present for jury selection, and those proceedings are ongoing. We have a difficult time getting people to participate and do their civic duty. If people were to react emotionally, it's going to affect the jury one way or the other, regardless of the decision, and that dissuades people from cooperating. So if you cannot control your emotions, you must leave at this time. I take this very seriously. I will put people in jail if they react emotionally. If you can't handle being here, do not be here for this. It is an emotional situation. And the reason is, as I stated before, my interest as a judge is to get people in the community to participate and be jurors. Anything that happens that dissuades them is taken very seriously. So you're welcome to be here, but if you can't handle the situation, please exit into the hallway and you'll find out what happened. All right, everyone's remaining with that admonition. Let's bring in the jury. We'll receive the jury's decision in this case. All right, the jury is entering. All right, Ms. Bickley, the foreperson of the jury, if you please hand the jury's decision to the bailiff for my consideration.
Shall we remain standing at this table, Judge?
Yes, please, actually. Let me review the verdict. You may be seated at this time. The verdict form is in proper form. The clerk shall publish the verdict, omitting the caption.
As to the murder of Tania Wise, we the jury find as follows. As to the defendant, Jose Soto-Escalera, aggravated factors. We the jury unanimously find that the state has established beyond a reasonable doubt that Jose Soto-Escalera was previously temporarily convicted of another capital felony. Yes. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of Tania Wise was committed for financial gain. No. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of Tania Wise committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. If you, the jury, answer no to every aggravating factor listed, you have completed your deliberation as to count 1. We, the jury, find by a vote of 8-4 that Jose Soto-Escalera should be sentenced to death for the murder of Tania Wise. Verdict as to the murder of the unborn child of Tania Wise. Aggravated factors. We the jury unanimously find that the state has established beyond a reasonable doubt that Jose Soto-Escalera was previously contemporaneously convicted of another capital felony. Yes. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of the unborn child of Tania Wise was committed for financial gain. No. We the jury unanimously find that the state has established beyond a reasonable doubt that the murder of the unborn child of Tania Wise was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We the jury unanimously find that the state has established beyond a reasonable doubt that the unborn child of Tania Wise was a person less than 12 years of age. Yes. If you, the jury, answer no to every aggravated factor listed, you have completed your deliberation. We, the jury, find by a vote of 8-4 that Jose Soto-Escalera should be sentenced to death for the murder of the unborn child of Tania Wise. dated this 25th day of September 2025. Four-person Aria Bigley.
Please be seated. I will poll the jury this time. Ms. Busa, does the decision announced by the clerk accurately reflect the jury's decision?
Yes.
Ms. Sedano, does the decision announced by the clerk accurately reflect the jury's decision?
Yes.
Ms. Robinson, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Edwards, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Johnson, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Clark, Mr. Fleischer, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Ms. Decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Mr. Does the decision announced by the clerk accurately reflect the jury's decision?
Mrs. Yes, Your Honor.
Ms. Holmes. Mr. Majak, does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
And finally, Ms. Does the decision announced by the clerk accurately reflect the jury's decision?
Yes, Your Honor.
Thank you. Ladies and gentlemen of the jury, the decision of the jury is accepted by the court subject to further proceedings. It does conclude your service in this case. Before I release you, I want to instruct you of a very special privilege enjoyed by jurors, and that is no juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For centuries, our society has relied upon juries for consideration of difficult cases, and we have recognized for hundreds of years that your deliberations, discussions, and votes should remain your private affair as long as you wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although at this time you are at liberty to speak with anyone about the case or your deliberations, you are also at liberty to refuse to speak to anyone, especially in a case of this nature, of this magnitude, in a high-profile case. A request to discuss either your verdict or your deliberations may come from those who are simply curious, or from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere, and it will be left up to you to decide whether to preserve your privacy as a juror. Especially given your incredible time commitment and patience that you've had in this case, before I release you, I want to thank you so much for your time and commitment to this case. On behalf of the flags behind me, the United States of America, the state of Florida, thank you for your service. At this time, it's complete, and at this time, the ballots will assist you in leaving the courthouse. Thank you. All right. At this time, the defendant, of course, remains remanded in the custody of the sheriff pending further proceedings in this case. You maybe all be seated. With regard to the Spencer hearing and the sentencing, I have proposed timeline with some dates that are subject to the attorney's convenience and approval. For the Spencer hearing, I have the week of October 6th with Monday, Tuesday, Wednesday, and Friday, which is October 6th, 7th, 8th, and 10th at 1:30 as possible times. And then my intent would be after the Spencer hearing on one of those dates at 1:30, the sentencing would be in early November November 3rd, 4th, 5th, or 6th, which is Monday through Thursday at 9 o'clock in the morning. Did you all want to consult with your calendars and tell me what you think would be better for you?
Ms. Minton will answer for the defense.
Sure.
I'll go to it anytime.
From the state?
I'm good for any day on the Spencer hearing. My request, I have a date certain trial on November 3rd in Indian River County, the week of. Does the court have any dates available after that week?
Let's see. If you just need to be in trial, Mr. Cormier could be here just for the sentence pronouncement, because there'd be no attorney involvement in that. So I really would not want to go later than that. I could go earlier than that, too. It's possible to go earlier than that, but that might be somewhat problematic. The reason I don't want to go earlier or later than that is, of course, my retirement is coming up, and as you know, as I mentioned, cannot work on this case whatsoever come the end of the year. So there may be some proceedings or administrative matters to me, depending on what the ultimate decision is in that time frame. So, and then when you say date certain in our business, really date certain or not really? Date certain subject to last minute requests for continuance, so forth. But
Well, Judge Meadows set it for a date certain back in like June or July. And I've spoken to the public defender. It looks like we're both going to be ready. Of course, anything can happen.
and that's as far as the actual sentencing goes, that's really secondary because that could be adjusted. The first matter is to have the Spencer hearing. That's the most important aspect of this. You're looking at your calendar, Ms. Minton.
October 6th is good for me, Judge.
October 6th, 1:30?
Yes, sir.
Does that work?
Yes, sir.
All right, so let's go with October 6th at 1:30. And my suggestion regarding that would be depending on what your request is, you could either get do your arguments orally or in writing or both. If you are going to do them in writing, it might be better to get them to me a bit earlier than that, just so I can ponder them before I come to court if I have questions. But either way is fine. There's really no set procedure there. Also gives you the opportunity to present further evidence by the defense at that time. All right, anything else for us to address at this time until we come back on the Spencer hearing?
No, sir.
Judge, can I ask Mr. Richardson? Mr. Richardson, do you want to address count 3 and 4?
There's 2 remaining second-degree murders from a previous information that was filed. The second one, that's on all process of both of those.
Okay. All right, and we'll see you then October 6th, Monday at 1:30 for the Spencer hearing.
Yes, sir.
Thank you.
Thank you.
All right, so court will be adjourned until that time. That'll conclude our proceeding for today. Oh, they should get that from the clerk. Yeah.
No one down there?
Is no one down there?
If you could just type something up saying that they were here and sign it so we can give it to their employer.
How many jurors?
11 of the
11 of the 12?
Take one and I'll copy it.
There's no one from the jury clerk office to give them that? Because that normally comes from the jury clerk. The jurors are asking for a work slip from the judge.